Okay, so we have another First Amendment speech case, and this one is Brown v. Entertainment Merchants Association. What was that one about?
That was a target to a California law that prohibited the sale of violent video games to minors. And it was an overwhelmingly good decision in the sense that they upheld the free speech rights of even minors, which is positive, but it was a split decision in terms of the basis for them upholding the law.
It was a 7-2.
It was a 7-2 decision. And surprisingly, we were talking about this earlier, Breyer dissented, as did Justice Thomas. Breyer is not known to be
hostile to
the First Amendment. Yeah. So it's curious that he found this law did not violate the First Amendment. I think one of the biggest problems that people have with the law, or at least the Supreme Court, was that the state failed to show any correlation between the quote-unquote violence in the video games and violent conduct by minors. But I do think it was a very strong First Amendment case in that it was scrutinized like the Westboro Baptist Church case, using strict scrutiny, which means that it's afforded the highest level of protection. There has to be an overwhelming interest, and it has to be the least burdensome alternative to not burdening the speech. So in this particular case, they said there was no correlation, and they also found that they didn't really define what violent video games.
So too vague.
It was vague, and that was the differing, that was like the concurring opinion said it was a vague.
So this California law banned certain kinds of video games for minors.
For minors, right.
And they didn't define well enough what certain kinds of video games meant.
And there was also some discussion in the case about the fact that the industry had voluntarily gave warnings about the content and had a rating system so that parents were in a position where they could make a decision whether or not these games were appropriate for their children. And in the dissent, Thomas goes on at length about the content and draws a very graphic description of some of the video games that were at length in an attempt to say that, you know, it's, and I find it ironic as well because in the previous case, Snyder, Alito wrote a dissent. He was the only one who dissented in that case. And he made some comment to the effect that freedom of speech is not a license to give a vicious verbal assault. And as a matter of fact, it is. That's how important our First Amendment is, that you do have to tolerate things that you don't like or find an alternative to not listening to it, but that the government's not going to get involved to protect you from First Amendment speech.